This morning, meanwhile, Hunter Biden, the president's son, is scheduled to appear in federal court in Wilmington, Delaware. He's expected to plead guilty to 2 federal misdemeanor counts of failing to pay his taxes, a deal that would allow him to avoid prosecution on a gun charge if he meets certain conditions. U.S. District Judge Mary Ellen Noreika, who was appointed by Donald Trump, will consider whether to accept that plea agreement. So, Danny, let's walk our viewers through again, because there's so much swirling around Hunter Biden. What the House is looking at is something different, talking about his business dealings overseas and possible connections to the president, which have not been shown so far. What are we talking about here? Just remind our viewers exactly.
Much narrower. These are 2 tax crimes to which he'll plead guilty to misdemeanors. And then in addition, he will enter into a pretrial diversionary program for gun charges. And what that means is pretrial diversion is kind of a one free bite of the apple. You enter into a program. Typically, you're monitored by probation. You have to behave. You go to work. You do everything you're supposed to do. Maybe you go to counseling. Then you come back, usually in 6 months or however long, and the judge will dismiss the case. It is ordinarily as good as a not guilty. There is the rare situation where I will not rush to accept and offer a pretrial diversion in any case. The reason it's controversial in this case is this. In state court, pretrial diversion happens all the time. You see it for DUI cases, low-level drug cases. In federal court, it happens virtually never. I'm not even aware personally of either any of my cases or any of my colleagues' cases where pretrial diversion has ever been offered in the federal system. So no matter how you cut it, pretrial diversion as an offer is very rare in federal court.
Does the judge have any options today?
Technically, yes. She can reject the plea agreement. That's always something you have to warn your client of. But I doubt that's going to happen in this case. It very rarely happens. Ultimately, the punishment is up to the judge. But when the government makes a recommendation, as it's expected to do here, which is no jail time for the misdemeanors, typically the judge follows it. Now, what I will say is in the federal system, if you're charged with misdemeanors, you have a pretty good chance of getting a probation-only sentence. But the reality is this. I'm aware of virtually no cases in the federal system where someone is charged with misdemeanor-only crimes. Misdemeanors by themselves simply they're just a rare animal in federal court. They are usually accompanied by several felonies, all of which will land you in prison ordinarily, even if you're a first-time offender.
So obviously, Danny, as you've heard many times, the accusations when we heard about this plea deal from Republicans is that Hunter Biden got off easy, that it's the Biden Justice Department. Again, this is a Trump-appointed federal judge. We should remind our viewers, from your point of view, clear-eyed legal view, take politics out of it, was this a fair deal? Was it a tough deal? Did he get off easy?
It was an amazing deal. And frankly, if the government's going to start handing out pretrial diversion like this, I'm going to get in line because it's an amazing deal. Like I said, it gets you just as good as not guilty. You can get your record expunged, at least in state court, depending on the state. It's as good as if you went to trial and won. So if the government is now in the business of ordinarily handing out pretrial diversion, then consider my hand raised. Now, I do understand the argument to be made that, look, in a tax case, this is something that might have been worked out. I understand that. And there's even an argument made, and I disagree with this, that under this particular subsection of the gun charges, now there are several different kinds of gun charges in this section. One is, for example, do you have a gun and are you a felon? Well, Willie, that's something you can look up very easily. There's the person with the gun. We know that. And we look on the record. Is he a felon? Then he's disqualified. But this subsection is a little squishier. This is the part that says, are you a habitual user of drugs, including things like marijuana, virtually, any illicit drug? If so, well, that's a lot harder to prove, right? I mean, arguably, you could go for the weekend to Amsterdam as a gun owner, partake in marijuana, and technically, under a reading of the statute, you may have violated it upon your return to the United States. I'm giving a ridiculous example, but it is true that that particular subsection is probably less charged and harder to prove. But look, pretrial diversion for a gun case in federal court is an amazing deal. I don't care how you slice it. And if you disagree with me, show me the statistics of people charged under that particular statute of percentages of people who get pretrial diversion for gun cases.
So is Hunter Biden the only one who could have gotten this amazing deal?
I don't know about that. I mean, I'm not going to go so far as to say that it was some kind of political influence, but it must be amazing lawyering. Look, it's the kind of thing that maybe, and I wrote a column about this, maybe it factored subconsciously or consciously into the government's mind. They have to consider whether they can get a conviction. Well, factoring into that decision, do you have to think about, hey, this is a very well-known defendant, and if we try to seat a jury, we may have a hard time convicting this particular defendant. And I do agree that this particular subsection of the gun statute is harder to prove. But look, if you need to prove that Hunter Biden was an abuser of drugs, I think there's a lot of video and photographic evidence that that was going on, including a book. So your burden of proof might be a lot easier than it would be with an unknown defendant. But look, I understand the arguments that this kind of tax case might or might not have been brought. I get that. But I just can't back down from the idea that in federal court, gun charges under this particular statute, pretrial diversion is a gift from heaven.
So, Danny, help our viewers understand what happened last night, I guess it was. There was a strange moment where one side is accusing the other of impersonating someone else in a phone call to the court to introduce new evidence. What exactly happened there? Is it significant to this hearing today at all?
There's a lot that's disputed and a lot that's not disputed. Here's what's not disputed. The House GOP filed what's called an amicus brief. It's a friend of the court brief. Now, when that happened, it included a lot of stuff that was not great about Hunter Biden. So Biden's attorneys looked at it and said, first, hey, listen, an amicus brief is a friend of the court, but what business is this of yours anyway? You're late. This is like coming in the night before the hearing. It's not really appropriate. So they got on the phone and they disagreed, and they emailed back and forth, nasty grams, as lawyers do. So then from there, it gets a little confusing. The phone call ends or the communication ends, and then apparently someone from Latham and Watkins' office, which, by the way, is a top-flight law firm. This is not a a fly-by-night law firm operating out of a strip mall. This is a white shoe, fancy law firm, very competent lawyers. Someone from their office calls, not a lawyer, but a veteran member of the staff calls and says, according to her, hey, what do we do about this? There's a document that contains sensitive information. You're not supposed to file information like Social Security numbers, other tax information on the public record. So she calls, and according to her, she says, what do we do? Should we file a motion to seal it? Should we do something else? And according to Latham, that's all they did. According to the court, apparently, the court clerk, what they did was much more nefarious. Apparently, reportedly, they called in and said, hey, we are the GOP. We're from the GOP's law firm. We accidentally filed this document. We need to pull it. We need to take it off the system. That's at least apparently what the court clerks are saying. It's going to come down to who does the judge believe. So if the judge believes that someone from Latham called up and said they were someone they weren't, that's going to be a big problem for Latham.
You were saying you'd be shocked, or you find it unlikely that someone from a firm like that would impersonate someone else because of the potential consequences for this case.
Yeah, I love it. Yeah, I love a good controversy. But when you think about it, just something is, here's what I focus on. If I'm a lawyer at Latham, if I'm a partner, a high-ranking lawyer at Latham, and even if I was going to do that, and I'm not saying any of them would, but if I was going to call up a court and pretend to be somebody else, I don't think I'd farm that out to a veteran staff member because that's going to create a paper trail. It seems to me that this might have been just a misunderstanding. I mean, oh, what a juicy controversy it would be if someone had called up and pretended to be someone they weren't. But I don't know that we'll ever get to the bottom of this, and that's the reality of litigation, is sometimes you never find out the truth. I think you're just going to have someone from the clerk's office saying, hey, I believe they were representing themselves to be someone they weren't. And you're going to have someone from Latham's office saying, probably swearing on a stack of Bibles, that I absolutely did not do this. And the judge is going to have to decide. Now, if I'm the judge, I'm going to err on the side of not sanctioning people unless I have some pretty clear evidence that sanctions are appropriate. So this may end up being a controversy for 24 hours. I wouldn't be surprised if the judge says, look, this is very serious, but I can't really find that anyone did anything intentionally. That's my prediction. I'm often wrong.
Maybe we'll learn more at 10 o'clock this morning when Hunter Biden appears in court in Delaware. Danny Cevallos walking us through it step by step. Great job as always. Thanks, Danny.